First of all, thank you for staying until the very end. So that's the final presentation. Thank you for your patience. So just a quite legal disclaimer. By staying here, you've implicitly agreed to my term of service, which is clause 1.1, no sleeping until the final slide. Thank you for your cooperation, and I promise to make this transaction worth your time. So now let's go through my presentation, which is about only the unknowable, the virtual property in the Genshin impact. As I was just talking about term of service, so my presentation is also related to term of service. So let's first see what is exactly an end-user license agreement. Well, an user license agreement is a legally binding contract between a software developer, the licensor, and the user, the licensee, that sets the term for using the application. And this is an example of a Genshin impact end user agreement. We can see from the above that it said, you acknowledge that your use of the service does not confer you any right or interest of otherwise in any aspect or feature of it, including but not limited to blah, blah, blah. So it didn't give the users any ownership. It is just a license. So that comes the question. So the phenomenon is that millions of users, they invest substantial time, money, and emotion in acquiring all these digital assets. But the legal reality is that the EULAs, they explicitly negate ownership. They're granting only a revocable license. So the developers, they retain absolute control over assets' existence. So also, we can see that, so my research question is, how do Genshin Impact players, they preserve ownership of their in-game assets within the legal frame of EULAs? And my director framework is adapting from an organizational context to the virtual spaces, and how do I consider whether the owners, the users think they have ownership. I conduct from three elements. The first is about their feelings of possession, and the second is about their identity extension, and third is about their preserved control. So the methodology is a mixed approach. I will first consider to doing some doctrinal legal analysis, and then I will compare with some data. So let's first go through the doctrinal legal analysis. I analyzed three main jurisdictions, which is US, EU, and China. So for US, we draw from an important case which established that the user is only a licensee, it's not an owner. So if the agreement specifies the user is granting a license and it restricts the user's ability to transfer the software, and it also imposes user restrictions. So this means that it prevents users from claiming ownership of high-value assets. So if the EULA is breached, the developer can then terminate service without any compensation. And China has the service claim, which is quite similar to the US. So the key case is Li Hongchen versus Beijing Article Ice Technology. And this case ruled that the items represent the player's labor and financial investor, and the developer had a contractual obligation to provide a secure environment. So the characters are virtual property, and the current judicial practice treated them as a service claim. So if a server shuts down or account is banned, the players cannot sue for the market value, only for a refund of an unused currency, not the characters themselves. And now let's go through EU. EU views video games as very complex works, and from at the beginning, the judge established the exhaustion doctrine. So once a developer sells a copy of a program, they cannot stop its resale. However, currently there is a new case redefine this stance, ruling that the video games, they are not pure software, they consist other things. So it can be classified as a complex works. So it also including art and narrative. So it cannot sell from a user to another user. So as a continuous service with artistic updates, it is exempt from exhaustion. The players cannot resell accounts because they are transferring a non-transferable personal service contract. It's not a software. So the jurisdiction analysis overview is that the 3 jurisdictions, they mainly consider it as a license, not something that can be owned by the players themselves. Then let's go through like what the players think, what's the players' reality, how do they really think about these things. So I conduct some online surveys. Section 1 is about the engagement and behavior profiles. I asked some questions related to financial investment and also the labor investment and the assets valuation. And then I conduct the psychological ownership skills. So I asked them mainly from 3 dimensions. The first is about possession, the second is about the identity, and the third is about whether they think they have control over the games. So let's go through the first dimension, which is possession and exclusivity. So this dimension mentions the extent to which the players perceive the digital assets as their exclusive private property despite the lack of the legal ownership. And the second dimension asks questions like, if my account were deleted, I would feel as though a significant part of my personal history or myself was erased. So I was trying to know whether the digital assets can be viewed as an extension of the personal self. And the dimension C is about perceived control and vulnerability. I would like to ask the players whether they think they have the right to control of the assets in the game. And then I also asked about the legal perception and their moral economy, whether the terms allows the developers to delete accounts without compensation, or whether they are viewed as unconscionable regardless of prior agreement. So the conclusion is that there is very high scales in moral economy and psychological ownership. So it means that the users has a very strong sense of entitlement despite the legal restrictions. And there's also a very low score in the perceived control, highlights the digital tenant anxiety gap. Like the users say no, they are just like tenants on the ground. And there is a very high, and the spending and position, these 2 elements have a very strong correlation, suggesting that the financial investment directly fuels the psychological sense of ownership. And there is, if people invest very high labor in the game, then they will feel like strongly rejection of restrictive legal terms. So the players also operate under a traditional labor theory of property because they think they have invested sufficient time and energy into this game. So they think they somehow have the control. And also there is the digital tenant anxiety gap. So the risk for developers is that because we can see from the statistics, if it the developers only relying solely on technological things while ignoring the moral economy, then it will risk a permanent collapse of community trust. And there is a very strict tension between players' expectations and EULA restrictions, so it may lead to a legislative interaction regarding digital inherence and essence findings. Also, there are three main findings upon this research. The first is about psychological ownership is storing and widespread, independent of legal awareness. The second is that the players construct a moral economy of ownership based on labor and capital investment. The third is that there is a high emotional attachment coexists with low perceived control, so it producing some structural anxiety. So these are also the players' voice that do my interviews. So we can see that there is very a big tension. And I also have some recommendations about these. The first is that I think there should establish a quasi-property protection framework. Because the developer, they retains ownership of the underlying software code, the players should be recognizing as holding a vested consumer interest in some specific data areas. So this mirrors the property as a bundle of rights theory, while the right to exclude the others and also the right to use the games, they are served from the right to destroy the platform. So I think this could grant users a right to permanence. The developers would no longer be able to delete accounts for any reason without satisfying a high burden of proof. So it can shift the players from a digital tenant to a digital leaseholder with statutory protections. And another recommendation I would like to say is that we should address the digital tenant anxiety through some digital inheritance. So we can ask the legislative to mandate some platforms to allow the inheritance of the digital accounts, treating them as a part of a decreased person's estate rather than a non-transferable personal license. So by doing this, I think the players can evolve from a sharecropper on Mihail's land, like they're a digital tenant, into really being a citizen with some rights and some wealth. So these are my presentations, and thank you.
Thanks very much. Have we got any questions?
Hello, thank you so much. That was a great presentation. I just, on your last point, I thought that was interesting phrasing, like to be like considered a digital citizen.
Yes.
Say in a game like Genshin Impact is a really interesting idea. I just wondered if you could elaborate a little bit more on what you think that might look like based on
your research.
The
last point?
Yeah,
my recommendations.
Yeah.
Right? So currently it's like the users only have the license, so all the things they have, they were just maybe suddenly disappeared. So it's like a digital tenant. But like if we can ask the platforms to allow the inheritance of digital accounts, like these accounts can be transferred, inherited, so like treated as a part of a decreased personal estate rather than a non-transferable personal license, then I think the digital tenants issue may be are more easily to solve. And recently we can have with the help of the technology like the blockchain technology, so we can let all these information be preserved in a very long time, and also only the users, they can access the information. So I think so in that way they can be they will not be just a digital tenant but be a really citizen who has the rights.
I'm curious, sort of building on that again with the digital tenant stuff. In particular, I sort of think about, yeah, it is a good idea, but the questions I really have about a lot of this are what happens when the game might shut down. Like, and I'd love it if you could expand a little bit more on that, because yes, if you can transfer the rights to someone else, you know, that's great. But it seems to me like a lot of these games, well, they're very successful now. You know, you give it a decade or so, and it's more likely, if we're using a tenant metaphor, that they're going to decide to demolish the house and build something new. And just if you could expand it all on the sort of potential solutions and protections in that regard that you might see.
Yeah. So if the games they're shut down, then maybe it's very hard to compensate. But if there's a possibility of that, even the games they are shut down, the contracts still exist, and like if the users still have some money in that platform, then maybe they can also sue for compensation in that regard. But it has to be a very hard method. Like, yeah.
Yeah. Thanks.
Yeah. Let's continue that thinking about the shutdown of a particular game. It's very likely that the company would not have the money to compensate the players, so the company would just go out of business. Yes, and then the player also gets nothing.
Yes.
So where do we go from there?
Then I think if the players like they cannot get compensation like money. But if they can like form a players group, then it's still possible they can sue for their other rights.
There's no company to sue anymore. The company's bankrupt. There's no money. So you have on paper, you own these things. That's all you got.
Yes.
Is that worth it?
Then I think the users they cannot take any action because the persons they wanted to sue, they just disappeared.
Yeah.
Yeah.
Okay.
Thanks. Do we have a question over here as well?
It's turned on.
About the game shutting down problem, there are some games which after they shut down, they decide to make the game go offline. For example, Mega Man X Dive, they made it so that the game is available offline to play, and the players get to keep all their characters. So generally, it seems like when the games do this, the players are quite satisfied, which also makes me kind of wonder, do you know if there's any reason why more games don't do this? Or, I mean, maybe it's a bit out of the scope, but yeah.
Can you explain more about that phenomenon you just mentioned?
Sorry, I'll provide a similar example that I know of. So there was this game called Duelist, it's something like that. The game was not going to be commercially successful, so they stopped offering it as a game. But then they offered players all of the assets. They just released the assets into the public domain.
Yeah, so if the assets they are in the public domain and then the players, so they gave the assets to the players. Yeah. So that's like they transfer the assets.
Yeah, pretty much.
So that I think that's possible. And I think that's maybe also a solution to the question just now. Like if a company shut down one game, then if it is a very reputable company, then the company may own other games. So they can like transfer the assets from one game to another game to compensate the players. I think it's possible. Like if we really have the digital inheritance.
Thanks very much. That's all we've got time for, and that's our last session.